Hello, my name is Vivian Duncan and I'm the Director of the Cancer Advocacy and Elderlaw projects at the City Bar Justice Centre. Thank you for your interest in joining our projects, and the training today will be about life planning documents. In particular, basic wills, advance directives and powers of attorney. To give you some background, the clients that we assist through our projects are seniors aged 60 and over, and cancer patients and survivors who have asked us to prepare these documents. After the training, we'll ask you to return the volunteer information forms to us, and at that time we will enter the details into our database, and when we have cases come in, you will also receive notifications. And when you see a case that you're interested in, just let us know. The cases are given out on a first to respond to us basis. So if you see something, a case that you would like to take, let us know as soon as possible. We'll let everybody know once a case has been taken. So the clients that we will be assisting through the projects are low and moderate income New Yorkers, and their circumstances can vary. For our cancer patients, sometimes the cases can be very urgent. The patient may be in hospice or hospital and with declining health and need us to prepare these documents very quickly. So in those cases, we will send out a notification to our volunteers, and we will specifically say we need someone who can go very quickly to meet with this client, and the documents would need to be prepared quickly for them. Other cases may not be as urgent. We may be asking for people to go to the patient's home or possibly to a hospital, although they may be ready to be discharged. It does vary. For our Elderlaw clients, they may be able to travel. In fact, some of the cancer patients can travel as well, particularly if they're survivors. So the clients that you'll be hearing about will either be people who are in hospice or hospital or homebound, or they can travel to meet with you either here at the Bar Association or at your office. Sometimes for the seniors, they'll meet at a senior centre, but it's very flexible, and we like the clients and our volunteers to be able to work out what is suitable for both sides. So the clients that we have for Elderlaw is generally elderly people who have decided they're ready to prepare these documents, and they may or may not be able to travel to meet with you. Most of our seniors can travel in. We will always let you know in advance through the blurbs that we send out about the cases whether someone can travel in. The clients come to our projects in a number of ways. Sometimes they call us directly, or sometimes it's through a third party who makes the first contact with us. It could be a social worker, it could be the adult child of a senior. Sometimes we meet clients through the presentations that we do either at senior centres or at hospitals and cancer support groups. The client intakes that we do here first, we first find out whether the client is eligible for our pro bono services, and if they are, we will find out about what their case involves. So, for example, someone may want a simple will, others may want a simple will plus all of the directives, healthcare proxy, living will, and powers of attorney, and also a disposition of remains, all of which I'll speak about during this training. Once we have all the details, we will send out a short blurb to all of our volunteers, so everybody will receive an email detailing the case or cases that are available. And when you see a case that is of interest, please let us know as soon as you can. Some of the clients will be able to travel, as I said, to meet with you, and some will also be able to provide their own witnesses. Those kind of details will be included in the blurb so that you will know what you're taking on. Another important part of the project is that I am here to provide mentoring for all the volunteers. Obviously, some of our volunteers do not prepare life planning documents on a day-to-day basis, so this may be fairly new. So I'm very happy to answer questions and also to look over any draft documents as you prepare them. and I will provide comments and suggestions so that by the time you're ready to meet with the client for the actual signing, execution of the documents, you probably will have gone through a couple of drafts, and I will have helped if you have any questions along the way with that. So, as I said, this training is going to focus on simple wills, advanced directives, powers of attorney, and I'll also mention disposition of remains. But this first part of the training is basic wills. So first of all, the statute which governs the wills in New York is the New York Estates, Powers and Trusts Law, the EPTL, and some of those sections are in your written materials. If you have the written materials with you throughout this training, that should help you to understand what I'm saying. You will find at the beginning of each section, there are 3 sections, at the beginning of each section you'll find contents or index, so that you should be able to identify what I'm speaking about relatively easily. So I'll start by saying that there are a few sample wills in your training materials. Have a look at those. You will notice that there are certain clauses that come up just routinely in all of the wills, and so those should be in whatever will you prepare. Those sections should be in there. But it's very important for you to craft the will, to draft it in a way that is very specific to your client. So, for example, your client may have a co-op and wish to pass on that co-op or the co-op shares in their will, while another client may have actual real property. They may have a home in Brooklyn, for example, and it could be their real property. So in that case, your will would mention that. Many of our clients live in apartments, rented apartments, but they have specific personal property that they would like to give away in their will. So those sections you have to be very specific about, and it's specific to your client. I'll begin by saying that because our clients are generally low to moderate income, sometimes, particularly for our very low income clients, the question is, well, is there any point in preparing a will because they don't really have much? So why don't we just have the clients put everything that they have into joint ownership, and in that way there's no need for a will? And my response to that is that it always helps to have a will, even if somebody is relatively low income or very low income, for a number of reasons. For example, if you have joint property with someone else, there's the possibility that the joint owner, the joint owner with the client, could die before the client. And in that case, the client has ended up in exactly the same position. They'll now be the sole owner of that property. There's also a risk to the client's property if somebody has a bank account and they just make that a joint bank account with, for example, their adult son, so that when the client dies, the son will own whatever is in that bank account. The risk is that if something happens in the son's life, while the client is still alive, and that son's name is on the account, then the account is at risk, because if that son is sued or it becomes bankrupt, because that son's name is on the account, then the client's property could become swept up as partly owned by the son. So that is a risk, unless, for example, a bank account is specifically labeled as, for convenience account, so that it is clear that the son doesn't own any of the property in the account, that it's not a regular bank account, a jointly owned bank account, because then the assumption is that they both own that account. Also, a client could die owning more property than they expected or than they had at the time they made the will, and in that case, property that they know that they would have liked to give to somebody else, if they had that much there at the time, now it's just going to go by intestacy or some other way which they would not, if they'd thought about it, have wanted it to go. And I have had cases like that where people have died unexpectedly and ended up with a lawsuit on their estate, and money has come into their estate and it's gone to relatives, and that definitely would not have been the choice of that particular client. Another point is that there are no contingency plans. You can't make a contingency plan if you have some of your property go by just going through joint ownership and then the rest going by intestacy. You can't state where you would like anything to go. It could end up where the person has no intention of it going. Also, some clients, or many clients, assume that if they are married, all of their property on their death will automatically go to their spouse, and that their spouse will then leave whatever property they have to the children. And under intestacy, of course, that's not what happens. Under intestacy laws in New York, the spouse would get $50,000 of the decedent's estate, and half of whatever is left above that. And if they had children, the remaining half would go to the children. So that plan that people think it will automatically go to the spouse works fine if it's just a couple and they have no children. But if it's a couple and they have a child or children, then the surviving spouse will get $50,000, then one half of whatever is above that, and the children will share the other half that's left. And that can leave some of the spouses in financial difficulty. So that is not something else that people should think about. If you have any property in New York, it can be quite a substantial amount of money, and that small house in Brooklyn can very easily come to well above $50,000. So if you're talking about a house, then it can cause problems if we're thinking, well, the spouse gets $50,000 and then has to share whatever is above that amount. A client can also want to leave little gifts to a wider circle of the relatives and to friends. Of course, if you leave things to intestacy, that's not going to be the case. Also, a will allows the client to name a suitable executor to settle their estate, and also an alternate in case that executor can't act. And it also allows parents to make arrangements for any minor children that they have. So that's some of the useful reasons for preparing a will, even when someone has very few resources. Also, it is very helpful to use the will intake form or questionnaire that we provide in the written materials, because it helps to organize your thoughts when you're preparing the will. It kind of acts as a guide to keep you aware of the kind of questions you should be asking and the kind of information that you'll need in order to prepare the will and to get sufficient information. Another important thing to consider when you're preparing wills is testamentary issues such as capacity. And the required capacity for somebody to prepare a will is that the testator must be of sound mind and requisite age, so at least 18 years old, and they must be able to comply with the statutory requirements, and they should intend that the document is to be the last will and testament. So they must be aware that the document that they're preparing and signing is their last will and testament. The testator must also know, or the client should also know, the nature and extent of their property, the persons who are the natural objects of their bounty, and how he or she wants to distribute or dispose of the property. The formalities of preparing a will are that the will must be in writing, it must be signed by the testator, it must be published, meaning that the client must have made a declaration that the instrument or the document that they're signing is their will, and the will must be witnessed or attested to by at least 2 witnesses. So in New York State, the number of witnesses that are needed are 2. And it must be done in the presence of the witnesses and the testator. Under the EPTL, it's very important that all of the will formalities are complied with to make sure that it will be acceptable and comply with what the surrogate's court would expect. Another issue that is very important when preparing wills is undue influence. So when you're meeting with a client, it's very important to make sure that you have time to speak with your client alone. Many of the calls that come to us, particularly for seniors, come initially from their adult children. And for many seniors, they rely very much on their children to make appointments, to speak to doctors, to make certain decisions for them. And so it becomes less usual for them to sit down and talk about serious matters, as preparing a will would be, without the presence of that child or the children. So you have to explain, and we do this often when dealing with the clients and the children, to say at some point the attorney who is preparing the document must have some time to sit down one-on-one, alone, with the client. And one of the reasons is because of undue influence. What it really means is that it's the possibility that someone may have domination, if you like, over the mind of another person. And it could be very benign. It's just that someone has become used to having someone else making a lot of the decisions. But for the purposes of preparing a will, it's very important that you are able to say, if ever there is a question about or any kind of will challenge, that you had time alone to speak with the client and to ensure that the document that you're putting together, the draft will, does accurately reflect what they want. They're not being influenced by anyone else. So give them that time to speak with you alone, and we, if the issue comes up at this end, will also make sure that the client and the family member, that everyone is aware that at some point you, the volunteer attorney, will need some time alone with the client. Another important thing to do with this same point is that you should keep interview notes. So if you've met with the client, you should specifically say, spoke with the client alone, we discussed such and such. And also very important is that you should put in your notes, if somebody says to you, gives you reasons why they want to do or not do something, you should put those in your notes. For example, a client may say to you, I've got 2 children, but I only want to leave my property to one of them. I'm going to leave everything to my daughter. My son, 3 years ago, got into trouble with money, and he ended up stealing my Social Security, and he ran off, and I haven't seen him since. He has not got in touch with us, and he's, I've heard he's living somewhere else and living the high life. In that case, you would make sure you put in your notes that the reason why the client explained to you his decision for leaving everything to the daughter and to not leave anything to the son was because such and such. That, again, is something that can come up if there is a will challenge or some family dispute when the contents of the will become known. Then it is helpful to have a note in your own records that explains the background to how the client came to make those decisions. Another point you should be aware of is identifying property which is probate property and that which is non-probate or not probate. So, for example, probate property is property that is held solely in the name of the client and where there has been no beneficiary designation made, or property that would pass by intestacy if there was no will in place. And as an example of that, for example, you can have a 401k or an IRA, some other kind of pension instrument, and if the client has not named a beneficiary on that document, on that pension, then it's solely in their name. It's like a bank account solely in the client's name. If the client puts someone else on the pension, they name the person as the beneficiary upon their death, then that becomes something that is going to pass outside the will. There's no need for it to go through probate, it will pass directly. But if the bank account or some other property, for example the house, if it's solely in one person's name, then that is going to be probate property. For non-probate property, if the client has named someone else to receive the property, as I say, like with their pension, or if they have somebody named on their bank account to receive the contents after their death. And I'll point out that that's very different from naming someone as a joint owner of the bank account. If you name somebody to receive the contents of the bank account upon your death, which is an in trust for account or a Totten trust account, in that case, then that becomes non-probate property. And that kind of setup, it does not risk the person's bank account if someone else were to become bankrupt or was sued, because the property remains solely in their name and does not pass until they have died. You can do the same kind of thing, naming a beneficiary on insurance proceeds and on employee benefits, pensions, that sort of thing. Also any property that's in any kind of a trust. You should also check with your client to make sure if they've ever lived in a community property state. There are 8 states that are community property. Those are Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, and Washington states. If they've ever lived in any of those states, then all assets that were acquired during their marriage while they were living in those states are deemed to be owned 1/2 by each spouse. So when you're preparing their will, if there's still property that was acquired while they were living in those states, then each party can only make plans for his or her 50% share of that property. As part of the EPTL, there are certain presumptions about family members and the way in which property can and cannot be left, or how property would be distributed if you include someone or don't include somebody in the will. With respect to children, if the client has 2 children at the time of writing the will, but chooses not to include them in the will, and then he later has 2 more children, if he dies and that's his last will, then none of his children will inherit, because the presumption under the EPTL will be that the testator had meant to disinherit all of his children. As a second example, if the testator has 2 children at the time of writing the will and he leaves property to them in that will, and then he has 2 more children, but he's not made a new will, so they're not mentioned, then when that testator dies, all of his 4 children would share the property equally under the will. In the case of divorce, if a will is prepared during a marriage and then the couple divorces, all dispositions made to a spouse in the will, and that's whether they are as a beneficiary or if they're named as the executor or as a trustee in the will, all of those dispositions will be treated as if the spouse had predeceased the testator. So none of those will stand. But very importantly, while that acts for a will, that is not the same for other documents. So, for example, if a client prepares a will naming the spouse as beneficiary and perhaps as the executor, and also names the spouse in as the beneficiary on the insurance documents, insurance policies. If at the time of divorce nothing has been changed, as I said, under the will, then the ex-spouse will be treated as if he or she had predeceased. But for the purposes of, for example, the insurance policy, that will remain in place. And the same thing for a designation of like a pension at work. So it's very important in a case of divorce that a client make sure to change those designations if that's what he or she would want to do. In the case of a marriage that takes place after a formerly single person has made a will, that client then gets married, does not make a new will, and then dies. Under the EPTL, the spouse will have some protections because they would have a right as the spouse to an elective share. And what that means is that if you are the spouse of someone when the person dies, then you are, under that law, entitled to get something from the person's estate. So one of the key points to make here is that you cannot disinherit your spouse. There are clients, and this always causes some consternation and some laughing, and it always gets a reaction when I do presentations, and I tell the clients that you can't just leave your spouse out. Well, you can not name your spouse, but that doesn't mean that the spouse is now barred from getting anything from your will. So it comes as a surprise to many people to find out that if they've split up with their spouse, you haven't seen this person for 2 years, you're living apart and you think of yourself as, I've moved on, but you've not got either a divorce or a legal separation, which is very different from living separately. Without a legal separation, then if you were at the point now, if one of you dies, then the other person is still your spouse, and as such entitled to elect to take their elective share. So if we have a client and you find out that the client is, sometimes client will just say they're not married, or I'm separated. That's usually what it is, we're separated. It is very important for you to find out when the person says we're separated, to see if they mean they're just living apart or that they've got a legal separation. Because the elective share can take up a substantial amount of the person's estate. And in New York, the elective share is equal to $50,000 or 1/3 of the deceased spouse's net estate, whichever is greater. So it is very important to let your client know that although they may think of themselves as essentially divorced because they're living apart, under the law, by law, that's not the same thing at all, and there can be fairly serious consequences. They might decide not to do anything about it, but at least they will know, they'll be informed. I'll also point out that there's no right to an elective share under certain conditions. For example, if the spouse permanently abandoned the testator, or if the spouse was legally separated from the testator, or if the spouse failed to support the testator despite having the means or the ability to do so. And you can also waive, an elective share can also be waived in a prenuptial agreement. Another important point is that you can disinherit relatives. So except for the spouse, you can disinherit relatives, including children. There's no obligation to leave property to children. But you should, if a client says, I don't want to leave anything to one of my 2 children, you must counsel the client that it's not enough to just not mention that child in the will. The child should be mentioned and specifically disinherited. Otherwise, there is scope for the claim that, oh, you know, at the time my father made the will, I believe he did not have the mental capacity to be able to prepare it. He obviously forgot to mention me. He just forgot. So you do not leave that as a possibility. All of the children should be mentioned, and anyone who's not going to receive anything, specifically say, it is my decision not to leave anything to A, B, and C. The types of bequests that you'll be dealing with will tend to be personal property, which typically would be household furnishings, furniture, clothing, could be china, jewelry, silverware, photographs. All of those kind of things would come under personal property. And sometimes the clients will just say, I leave all of my personal property to my son and my daughter equally. That kind of property can also be as a specific gift, as in I leave my gold ring, which I inherited from my grandmother, to my daughter, and I leave my collection of gold coins to my son. So that type of property is personal property, and it's generally referred to as tangible personal property because it's the kind of property that can be seen. You can see it, you can touch it, you can pick it up, you can look at it. So that's tangible personal property. Another type of property is intangibles, but that's more for the kind of property that is, for example, stocks and shares, or any kind of intellectual property, copyright, rights, the sort of thing that you can't just look at and see it as a physical item. Money is kind of in an ambiguous area between being tangible and intangible. Generally these days people tend to think of it as tangible, but if you want to be very all-inclusive to make sure that whatever property the client has, any personal property will be included, then you can say, I leave all my property both tangible and intangible. You can just put that both in there, put that in there, and everything will be covered. Another important point is that many people who live in co-ops, because they're obviously living in an apartment, you would assume that it's an apartment, so that it's real property. But be aware that co-ops would not come under real property. Co-ops come under personal property, because what is being passed on are the co-op shares. So you have an example in one of your sample wills in the written materials. One of the clauses there is the kind of clause that you would use if you are going to be passing on a co-op. It must refer to the testator's, the client's address with the apartment number and the client's shares in the co-op corporation. And you should also look at the proprietary lease and any other documents to do with the co-op to make sure that the client has the right to pass the co-op shares on without any kind of restrictions. For some co-ops, they specifically require that the owner of the co-op shares must come within a certain financial eligibility, and those are the kind of co-ops where they are trying to keep it affordable, to not make it a market rate co-op that people may not be able to afford. So they may require that anyone who owns a co-op shares must have an income of, between, for example, $50,000 and $150,000 a year. And so it's very important for you and for the client to know if they're planned to give their co-op shares to their son who earns $300,000 a year, that would not work when there are where there's a kind of a restriction on ownership of those shares. So please speak with your client if the client has a co-op, and make sure you get that kind of information ahead of time. If the client has real property, that your will should definitely include a real property clause that specifically disposes of that property under that devise. So if disposal of real property is called a devise, and the recipient of that property is the devisee. So be aware that you would not just leave, if you know that somebody has real property, don't just leave that to be passed on in the residuary clause. If you're aware that he or she owns property, put that in its own separate clause. And for anything left over that you've not disposed of either under personal property or real property, then you would always include in every will the residuary clause, which is like a catch-all for everything else, just in case somebody acquires some property after they have prepared the will, and so something may not have been disposed of in the will by the time the client dies. And you'll find in all of your sample wills there is a residuary clause which generally says something like, I give, devise and bequeath all the rest, residue and remainder of my property and estate, both real and personal, of whatever kind and wherever located, that I own, or to which I shall be in any manner entitled at the time of my death, hereafter my residual estate. So always include a residuary clause in any will that you prepare. With respect to distributing the property, people can get very confused about the term, per stirpes, when to use that. You can also use by representation, per capita. Generally these days, many wills you don't have to use the term per stirpes if you have described the way in which you want the property to be distributed, or in the way that the client wants it to be distributed. It can be set out very clear without using the words per stirpes, which for non-lawyers can be very confusing, because if you don't say what that means, it means nothing to the client. So it's possible to, for example, if the client says to you, I have a son and a daughter and I want them both to inherit what I have equally, then you should follow up and say, okay, in the event that one or both of your children were to predecease you, what would you want to happen to your property at that point? If the client then says, well, I would like my property to go to, my son has 2 children and my daughter has 1, so if one or other died, I would want that child's property to go to their own children or child, then you can put it in those terms in the will. You put their names, and you very easily can just say, if Anne were to die, then her share of the property goes to her child. If my son Bob were to predecease me, then his share of the property to go to his 2 children equally. Now that's per stirpes, so you don't even have to use the word per stirpes. You can just set it out that easily and clearly. But to give you some idea of the 3 different types of distribution that can be given, whether or not you decide to use the terms, but just so when you're discussing this with the clients, you and they will be aware of the different types of distribution, the ways in which the distribution can be made. So for per stirpes, I'm going to use the same scenario for all of these. So we'll start off saying that the client has 4 children, A, B, C, and D. A has no children, B has 1 child, C has 2, and D has 3. So if the client decides that he wants to leave his property per stirpes to his children, in the first example, I'll say that children B, C, and D survive the client, but the first child, A, has predeceased him. If by per stirpes, it means that B, C, and D would each receive 25% of the testator's estate, and A's estate, the deceased child, her 25% would be shared equally between B, C, and D, because A had no children. As a second example, also with per stirpes, if A, B, and D survive the testator, but child C has predeceased him, then A, B, and D would each receive 25% of the testator's estate, and C's 25% would be equally shared between her two children. Finally, for per stirpes, if A and B survive the testator, but C and D both predecease him, then A and B would receive 25% of the testator's estate, and C's 25% would be shared equally between her two children, and D's 25% would be shared equally between his three children. So that's how per stirpes would work. If the estate is going to be shared by representation, and many people kind of use per stirpes and by representation as if they are the same thing, but there is a difference in the outcome in some circumstances. In some circumstances, it will work out the same whether you're using by representation or per stirpes, but in other scenarios, it will be a different outcome. So this way, in this example, the will says they are to inherit by representation. So now, in the first scenario, A, B, and D survive, but C predeceases the testator. By representation, A, B, and D will each receive 25% of the testator's estate, and C's 25% would be shared equally between her two children. So in that case, it would be the same outcome as if it was passing by per stirpes. The second one, where it would make a difference, is A and B survive, but C and D would predecease the testator. In this case, A and B would still each receive 25% of the testator's estate, but now C and D's children, which total 5, will share equally the remaining 50% of the testator's estate. So each of those 5 children will receive 10%. So C's two children, actually are worse off under by representation, because they would each have got 12.5% if it had gone by per stirpes, but they get 10% if it goes by representation, because all the children in a certain class, which is the grandchildren, who inherit, will inherit equally. They don't just inherit their own parents' share. So that's where by per stirpes and by representation can make a difference. And finally, per capita, this is where the survivors will take according to whoever is a survivor. It doesn't matter which generation they are in. So for example, as a first example, A, C, and D survive the testator, but B predeceases him. A, C, and D will each receive 25% of the testator's estate, and B's 25% will go to his one child. Again, that works out the same as if it was per stirpes. However, if A, B, and D survive, but C predeceases the testator, then C's 2 children will become beneficiaries. And so now there are 5 beneficiaries that are all on equal footing. So in that case, the estate will be divided equally between them, and each beneficiary will receive a 20% share. So again, if it goes by per capita, then A, B, and D will receive smaller shares than they would if it had gone by per stirpes. So it's good to discuss this with your client when you're preparing the will and find out exactly how they would like the gift to pass through the generations. And you can just put people's names or you can use these terms, but I would recommend that you name the children and grandchildren, or you specify it and don't just rely on the terms per capita or by representation or per stirpes. Other clauses to be aware of. There are samples, as I said, in the model wills that you have in the materials that would be related to, for example, co-ops, guardianship of minor children and distribution of property to minors. When you are preparing the will, always make sure that you have got all of the information about the names and addresses of anybody who's included in the will. Make sure that it's all correct, that you've got the spelling correct. Make sure if somebody says, I'd like to leave something to my brother Will or my brother Tim, you should check. So is the legal name Will or is it William? Is it Tim or is it Timothy? And it's fine for you to put William, even though everybody refers to William as a Will. If the legal name is William, then you should put William Smith or William Jones or Timothy, Brown. And then you can also put AKA Tim Brown. So, but make sure that the person's legal name is included in the will. You should also make sure that, which some of the clients do, you get their full name. They will quite often say, my name is, Anne B. Smith. You should ask, well, what does the B stand for? Because the full name should be in the will. Even though they usually will write down Anne B. Smith, what's the B? If it's Anne Barbara Smith, you put Anne Barbara Smith in the will. If they have documents that say Anne B. Smith, you can put Anne Barbara Smith, aka Anne B. Smith. But the full legal name should be in the will. When you're preparing the will, you should start with the preamble, which declares where the person lives, where the client lives, and where they are domiciled, which is the important point, because your will should be made in your place of domicile. And the place of domicile is determined by, if there's any question about it, if your client may spend some months in another state, like the snowbird who will go to Florida or South Carolina during the cold months in New York. If there is any question about where do they spend the longest time, you can ask, where do you vote? Where's the place that you vote? Where is your driver's license? Where is where's the registration? Do you own real property? Where is it? Where do you pay your taxes? That sort of thing. Another important point is the revocation. You must have a revocation clause in the will. That's in all wills. You revoke any previous wills and codicils made by the client. It's good to give a brief description of the immediate family situation, just an article or clause in the will that says something like, I am married to Bill Jones, or I was legally divorced from James Smith in New York State in 1995, or I am a widow, my husband John Smith died in 2005. You mention any children, I have 2 children, Charles Smith and Anne Smith. So just give a brief mention of the client's immediate family situation, particularly if there is a spouse or the person is widowed or divorced, and if there are children. There should be a mention of executors. Someone has to be named as the executor in the will. the person should be, when you're counselling the client, just make sure the client understands it should be someone who is trustworthy and competent, preferably someone who lives in the same state, who lives in New York, because if that's not the case and the will has to be probated, there may be a lot of things that the executor is going to have to do which may be difficult to do if they're outside the state, and it may be the kind of things that they need to do. They would have to engage, if they're not here, they'd have to engage a New York attorney. So that's something that the client needs to be aware of. Consider waiving the bond, because if that clause is not in the will, then there will be an expectation that the executor may have to pay a bond in order to carry out his or her duties, and you don't. Most of our clients, given the small amounts that they're going to be leaving, would not like to have their executor required to post a bond in order to to settle their estate. And you'll find wording to that effect in your sample wills. Some of our clients have trouble trying to think of someone who can be either the executor at all or an alternate, because it's always good to have an alternate executor in case anything goes wrong with the person first chosen. As a backup, if your client can't think of anyone whatsoever, consider using the public administrator of the public administrator's office in the county where the client lives. So that's for the executors. Another important clause, again, which you'll find samples in your materials, is you can decide that whether there should be any apportionment of any taxes that are due. For example, you can choose that the taxes should come from various gifts or bequests or classes of bequests, so that it's kind of shared between them, or you can say that any taxes are to come from the residuary estate. But I'll just point out that in our case, generally our project clients, their estates are going to be very modest, and they're not going to be liable for any taxes on their estate. An expense clause is also included, and for that deals with the payment of any debts, for example, any funeral expenses or that sort of thing. Generally, if you don't make any mention of it, then the executor is going to be required to pay, for example, the funeral expenses. So you can include a clause in the will saying that the expenses, any funeral expenses, any kind of expenses that come up after the person's death, should be paid for from the estate, through the estate, usually the residuary estate, but it should be from your estate, or you can say it should come from the proceeds of your bank account, or if you've set up an insurance policy that will pay for those kinds of after-death expenses, then that should be included in the will. Because, as I said, if nothing is mentioned, then the expectation is that that burden is going to fall on the executor. So make sure to discuss that with the client, and again, that wording, you can find the appropriate wording in your sample wills. You should include a simultaneous death and survivorship clauses in the will, and that's the kind of clause that says in the event that it cannot be determined which one of us died, then the assumption will be that the beneficiary predeceased the testator. Similarly, if the testator leaves something to a beneficiary, it is wise to put a survivorship clause which says in the event that any beneficiary dies within 30 days, for example, you can change the number, but generally 30 days of the testator, then it should be assumed that it should be treated as if the beneficiary had predeceased the testator, and that's in order to prevent there being two probate proceedings on a certain property within a short space of time. It also allows the testator to make sure that his or her property will go to someone of their choice, rather than have a property go into a beneficiary's estate and the beneficiary dies right afterwards, and it goes through the beneficiary's estate and then goes to that other person's family. That may not be what the testator would want. So make sure that you include a simultaneous death and definitely a survivorship clause when you're preparing the will. Some wills may also involve charitable bequests, may also include mention of the funeral arrangements. For example, if somebody wants to be cremated, in that case, I would definitely say you should consider preparing a disposition of remains document, which I will speak about in the second part of the training. But that is something, particularly if somebody wants to be cremated, or if they have put in place a prepaid funeral plan, or they may already have bought a funeral place or a burial plot in a church or somewhere else next to maybe a family burial plot. All of that should be in a disposition of remains document as well as mentioned in the will. Some people also want to leave like anatomical gifts, and that's something else that should be mentioned in the will. And if somebody does ask you about leaving organs or their body, full body donation, we have information here that we can pass on to you to give to the client about how that should be handled. The will should contain a testimonium clause, which is the in witness whereof paragraph, which establishes that the document is the testator's last will, and that's where the testator will provide his or her signature and the date. Below that will be the attestation clause, and that is the clause that generally starts, the foregoing instrument was on this date, on this time, signed, sealed, published and declared by the testator's name. So that's the clause that comes right above where the witnesses will sign. And as a pointer, try as much as you can when drafting the documents to format it in such a way that you get the testator's signature or the client's signature and the witness's signatures on the same page. If you can, get a little of the body of the will. For example, if you have 10 clauses, 10 paragraphs, articles in the will, if you can get even like the last sentence from the last clause to roll over onto the top of what's going to be your final page with the signatures, that's great. What we're trying to do is to not have, for example, the witness's signatures on the pages where that's it by itself. You want everyone's signatures to be on the same page. You don't want there to be any question of whether somebody did something that they shouldn't do to the original will, substituted pages, or just took the last page, the witness's signatures off another, the original will, and clipped it or stapled it onto a new will. You don't want there to be any question of that type. So you want everybody's signature, the client's signature, the witness's signature, to be on the same page, and preferably with a little bit of the actual will on that page too. Sometimes it's very difficult and you can't somehow manage to get it to do that, but it's something that you should be aware of when drafting the will. After you've prepared the will itself, you need to prepare a self-proving affidavit or an affidavit of attesting witnesses. Again, you have these samples in your materials. The purpose is to confirm that all the steps that are required under the EPTL were observed, and that it conforms with the due execution of a will. Be aware that the page numbering on the will should be on the will itself, even though the self-proving affidavit is going to be stapled to the will. They are two separate documents. So the will should have, the will should say at the bottom, page 1 of 4 or page 1 of 6. The witness affidavit should have its own numbering if it has any numbering at all. Sometimes you don't need to put a number because it may be one side or it could be just two sides. But the will and the affidavit should have separate numbering. The affidavit does not prevent challenges to the will if it's based on a lack of testamentary capacity or undue influence or fraud. It's really specifically to say to the surrogates court, we gathered the witnesses were both there when the client signed the document. The client seemed to be in full understanding of what he or she was doing. They knew it was their will they were signing. They agreed that the will reflected their wishes. So all of the requirements under the EPTL will be summed up in that client on the affidavit of attesting witnesses. That document needs to be notarized, so the affidavit is notarized, the will is not. The will is signed by the witnesses, but the affidavit is signed by the witnesses and is notarized. I'll also just point out, when the client is signing the will, make sure they also initial all of the pages of the will. So they'll initial the pages, and then at the end of the will, he or she will sign the will. Another document that you should prepare at the same time is a family tree affidavit, and again you'll find a sample in your materials, and this is for the client to provide the names and addresses as much as possible of their relatives, their wider relatives, and this would include obviously their spouse, children, grandchildren, their siblings, if their parents are still alive, nieces and nephews. This is especially important if we're dealing with a client who is not leaving any of his or her estate to family members. Family members, the surrogate's court will still be required to notify family members of the person's death, and it's very difficult for the surrogate's court to do this if they don't know where to find the person's family members. So please be sure to take a look at the sample that's in your materials and prepare a family tree affidavit. Explain to the client why it's needed, because it can hold up the probate process if, for example, the client is not only not leaving anything to family members, but if their executor is not a family member and would have no idea about the client's family and where to find them, it can cause a delay in the process. The will execution ceremony is very important. Also in your documents you'll find a kind of like a guide as to how it's supposed to be conducted. You will see that the requirements of the EPTL for conforming with the execution, that's included in the ceremony. You also need to make sure that you have conversation with your client in front of the witnesses to make it clear to everybody the witness was perfectly aware, they're not having any problems with their memory. Just have an ordinary conversation. Get them to engage, get them to talk, just in general. Can you make sure that you confirm in front of the witnesses? Can you tell me what this document is? The client will say, this is my will. You would then ask, does it accurately reflect your wishes as to how you would like to distribute your estate? Get a confirmation there. The client has to ask the witnesses to be the witnesses. I would like you to witness this document. So there are certain things. Read through what you will have to do, because you are going to be in charge of the whole execution ceremony, and it is a very important part of the overall preparation of this document, the will in particular, but of all the other documents you may be preparing and signing at the same time. So you will go through the step-by-step according to what you see on the guidelines for the will execution ceremony. And once again, to point out, the witness affidavit, the family tree affidavit, and the family tree affidavit, witness affidavit, they're notarized. The will is not notarized. And finally, just make a little memo to yourself, the same kind of file that you put together that would include your conversations with the client along the way, you know, saying why they have or have not left property to this or that person. Any kind of interactions like that, you will have put together a file which you will keep, and you should write a memo afterwards in which you give an overview of the execution ceremony. So you should recap all of the steps that you took, your conversations with the client, you know, you asked the client this, the client responded in the affirmative, you know, the client then asked the witnesses to serve as witnesses, you know, so you go through all the steps that you will have done, and you memorialize that in your memo, and you keep that in the file. And that's just in case any way along the, you know, in the future you have to give a statement or an affidavit or you know, say anything in surrogate's court. If there's ever a will challenge, which I point out now, as far as I know, we've never had for any of our clients, but this is what you should routinely do, whether you're preparing a will for somebody who has millions or somebody who has a very modest estate. This is just the routine that everyone should do when preparing a will. So that is the part one of the training for your basic wills, and in the next section we'll be doing advanced directives.